Well, depending on when you're watching this, either good morning, good afternoon, or good evening. My name is John Schelling. I'm the president and founder of TLS Financial Services, and I'd like to welcome you to our presentation, Smart Estate Strategies Beyond Your Will. When you registered, you received a profile on both myself and TLS Financial. And if you haven't already done so, I would ask you to just pause this program now and have a read over of that profile so that you get the background information on both myself and TLS, and then we can go directly to this presentation. The topics and strategies we're going to cover today have been garnered from my extensive experience over the last 27 years, not just helping clients plan and implement their financial and estate plans, but also the hands-on experience of processing those estates on those sad occasions when our clients pass away. So without further ado, let's move on to our presentation. Again, on this slide, I'm going to get you to pause and have a read over. This is basically a disclaimer stating that we're using general assumptions and forecasts on these presentations, and that anything presented here will probably vary materially from issues that you have, and that anything you undertake should be done with a professional advisor. So let's look at what in general estate planning objectives are, and I think they're pretty universal, and that is really, to paraphrase this, to get the optimal amount of assets to your beneficiaries quickly and cost effectively without compromising, and in fact maybe even enhancing, your current wealth and lifestyle. And again, the importance of this objective is that estate planning and wealth and lifestyle enhancement are not mutually exclusive of each other. One doesn't compromise the other. They should be done congruently, and they should work together. So let's talk about some of the topics we're going to cover today, or just review them very briefly. One is we're going to talk about estate taxation. We're going to discuss the various ways you can distribute your legacy. We're going to look very briefly at the Wills, Estates, and WESA, which is the Wills and Estates Act that was recently introduced into British Columbia British Columbia estate law. We're going to look at direct settlement methods and trusts and how they affect your beneficiaries and your estate planning. We're going to look at life insurance as well. And life insurance is not, in the perspective that life insurance is not just for the young. Whether you're 40, whether you're 80, life insurance can play a very integral and important role in your estate planning. Segregated funds, which offer investment benefits while you're alive, and also direct settlement to your beneficiaries when you pass. We're going to look at annuities, and we're going to wrap up by talking a little bit about networking and choosing advisors for estate planning. So let's talk first about the taxation of assets at death. The most important thing to understand is that when you pass, when you die, there's a deemed disposition of capital property, of your capital property, which is stocks, bonds, mutual funds, things like that. Also a deemed deregistration or disposition, if you like, of your RRSPs and your RRIFs. And so it's as if when you die, you have sold everything. And any tax consequences to the selling of these assets is claimed on your final return, which is usually the return that's filed in the year of your death. Your spouse, if you're leaving assets to your spouse, can elect to receive those assets without tax consequence, and we call that a tax-free rollover provision. Now, it can make sense sometimes for your spouse to elect to be taxed on some or all of the assets, depending on the marginal tax brackets that your spouse is in. Again, this is something you would work in conjunction with an advisor. If you have private company shares, they're also eligible for a or may be eligible for a lifetime capital gains exemption, which would exempt them from some or all tax. And your principal residence, just like in life, while you're alive, if it's deemed to be sold, it's exempt from tax. So when I'm talking capital property, as I mentioned before, I'm talking stocks, mutual funds, real estate, properties that you own. And we're going to take a look illustratively at a situation where we have a non-spousal deemed disposition. So this, you've died, you own an asset that has some tax consequences, and it's not being left to your spouse. So let's assume, for example, you have a stock portfolio and it's worth $500,000. The original cost of all your stocks was $100,000. So your value at death is $500,000. All the stocks in there originally cost you $100,000. There's a deemed gain on your portfolio when you pass of $400,000. Now, because only half of capital gains, which is what this in fact is, are taxable, your final return will show a taxable capital gain of $200,000. If you're in the highest tax bracket, $86,000 of tax will be applied against your deemed disposition. So in other words, even though you haven't sold the portfolio, it's going to attract $86,000 of tax at death. And this is important, and I will address these tax issues once we look at the second slide, which has to do with the disposition of your RSP or your RRIF to, again, a non-spousal beneficiary. So if your RSP is worth $500,000, 100% of it is claimed as income. Just as if you pulled it all out in one lump sum when you were alive, when you die, that whole $500,000 is deemed to be disposed of. It attracts the tax if you're at the 43% tax bracket, or your estate is of $215,000. So the net to your beneficiary is $285,000. So you should be aware, obviously, taxation can have a huge impact on your legacy, because if you have these tax bills to pay, whether it be the $85,000 we looked at in the slide before, the $215,000 on this slide, your beneficiaries or your estate has to find a way to pay that. And that's going to be either from other funds in the estate, it's going to, or it may require your beneficiaries to borrow or to sell the asset in whole or in part. And again, this requires planning to deal with. One of the more popular options in covering these tax liabilities is life insurance proceeds. And life insurance can be purchased to provide these funds upon your death and effectively pay the whole tax bill and keep all these assets intact at their value. So let's look at distributing your legacy. We now understand the tax consequences. One other thing I just want to mention, I'm going to go back to that slide. In the two situations we just looked at, capital properties and RSPs and RRIFs, the other thing that's very important is how you split up your asset. In the previous example with a capital property, we saw there was $85,000 of tax payable. In the RSP, there's $215,000 of tax payable for the same $500,000 value. So you want to be very careful when you're splitting your assets. If you leave one beneficiary your RSP and the other your capital property, ignoring the settlement of these particular assets, one beneficiary is obviously going to do better than the other, simply because the tax consequences are different. So you want to, when you're estate planning, not just plan for dealing with these payables, but the effect that it's going to have on the beneficiaries and how you split these assets up. So when you're distributing your legacy, you know, I'm talking about estate planning, and estates are really created obviously when you die. And when you die, what happens is your assets, those assets that are going to be handled by your will, go into a trust. A trust is formed. It's called a testamentary trust the minute you die. And that effectively is your estate, if you like. And it's interesting, we call this seminar or this presentation estate planning. We're really going to look at ways of settling outside the estate because, as you're going to see in a few minutes, that's the most optimal way. But for those assets that go through your will, money will go in, it will be put, or money and assets will go in, a testamentary trust is formed, and your will is the document that literally dictates how those assets are dispersed. Inside the estate, though, you're going to need an executor, and an executor is very simply somebody who is appointed by you or through your will to handle the disbursement of the assets. You may also need lawyers and accountants and other professional advisors depending on the complexity of your will. You're going to be subject to probate and fees. And the probate process is also important to understand in that probate requires a court action to verify the will and allow it to be processed by the executor. And because it's a court process, your will and your estate become public documents. Your will is also subject to something called the Wills Variation Act, which allows some people that may not feel they're getting a fair shake to attack the will and attack your will. And it's subject to beneficiary review. In other words, all beneficiaries are supposed to receive a copy of the will and review what everyone is getting. So this isn't the best situation possible for a variety of reasons. Obviously, you've got a bunch of people involved. You've got a process you have to go through that's both timely and expensive. And I've kind of emphasized here where you can see the large dollar on the estate arrow going in and a smaller dollar coming out to beneficiaries because you're going through a whole process. Now, if we go to what I've done in this slide is create a left side with the estate. The right side is what I call direct settlement. And this is really estate planning, estate strategies. This direct settlement is exactly what it states. It's a direct settlement to your beneficiaries. So there are vehicles around that will bypass your will, bypass the executors and all these processes you see, and settle directly to your beneficiaries. And that's what we're going to spend the majority of this presentation talking about. Those vehicles, and we're going to talk more about them in subsequent slides, are joint ownership, RRSPs, RRIFs, and TFSAs, which are tax-free savings accounts. We're going to talk a little bit about trusts. We're going to talk about life insurance, cash values, segregated funds, and inter-vivos gifts. Now, I'm going to address inter-vivos gifts right here. Inter-vivos, and pardon my crude Latin here, just means while alive, basically. And these are gifts that you can give out to your beneficiaries while you're alive, which would obviously avoid any type of settlement when you die. If you have assets that, particularly assets such as pictures, desks, furniture, other such items that have a sentimental value to some of your beneficiaries, and they're not particularly vital to your current lifestyle, if you can give them away now before you die. Very often in our experience, we see that will or estates get held up for the silliest reasons. Somebody or a couple of beneficiaries feel entitled to a piece of jewelry or a picture, or as I say, even a piece of furniture, and arguments ensue over that, and because of that, wills and the rest of the process gets held up. Whatever you can give away and you feel comfortable giving away without compromising your lifestyle or your sentimental values, do so now. So let's talk very briefly about the Wills, Estates, and Succession Act. As I mentioned, this estate planning is going to deal more with direct settlement, not with items going through your will. But we have to understand the will and what it's all about to understand why direct settlement is a better alternative where it can be implemented. So basically, we have what's now a new act called the Wills, Estate, and Succession Act, WESA. Been law since March 31st, 2014. And it's basically modernized some of the old rules that were in place for a long time. The most important factor with WESA is, from my standpoint, is if you haven't had your will reviewed lately, go get it reviewed by your estate specialist and make sure it's compliant and works within the new rules and regulations. Basically, the will, though, what is the will? It's a legal declaration, basically, where you appoint somebody to handle the distribution of your estates at death, or your property at death. The general rule is don't die without one. As much as we plan around the wills, there's still probably going to be assets that go through your will, and it's much better to have them documented where you want them to go than to leave, die intestate, and let somebody else decide where your assets are going to go and how they're going to go. Make sure they're prepared by a professional that specializes in wills. That doesn't necessarily mean a lawyer. A lawyer is a professional that works in the legal field. Make sure that the lawyer, if you use one, has estate experience. And be careful if they have no estate experience, because they can draw up a will, but you may end up with more of a mess than you require. So basically, anybody that you use to help you design your will should be a specialist in that area. Just a couple of quick points here on things you should consider when you're appointing an executor. Make sure, obviously, they're competent. That sounds pretty straightforward, but you wouldn't believe the situations I've seen where people have been picked because they're friends or family members and they just have no competency or didn't want to do this particular function in the first place, and really resulted in some bad situations. Make sure also they're likely to survive you. One of my dear clients who passed away some years ago when I originally met her, we were reviewing some issues with her portfolio, and we had brought up the will, or she had brought up her will, and her executor she was 82 at the time. Her executor was a lawyer friend of hers who was 88. And obviously that really didn't make a lot of sense, because not that this gentleman wasn't competent, but the fact was that because he was older and older than her, it was very likely that he may not be around to perform his functions, as he would probably predecease her. So she later changed that. I think family members are questionable, and unless it's your spouse, and the majority of the assets are going to the spouse, simply because you take a situation where if you have a close family, this could cause some stresses if one family member is distributing the assets of the will. If you have a dysfunctional family, then obviously, why would you have a family member as your executor? But I have often seen this result in a lot of tensions, even with close families. You should probably separate this function away to somebody that does not have an emotional tie. Beneficiaries, again, this is pretty common sense, but we don't see this very often. Have regular reviews with the beneficiaries. Part of the reason is that if you're going to leave assets to individuals, make sure they know who's getting what, because if there's going to be an argument, let it come out now, because it's going to be a lot more costly if it comes out after you die. Notify beneficiaries of all changes. If you're making changes, if you've had a review and then you make a change, then somebody might feel slighted. So make sure everybody you notify them all of changes, primarily, again, to avoid this possible conflict with the beneficiaries when you're passed. And again, taking these steps, understand that even if you take these steps, your ultimate legacy could be challenged under the Wills and Variation Act for anything that goes through the will. So let's start looking at the right side of that slide, which are the direct settlement options you have. Instead of going through the will, how can you set up assets so that they directly settle to beneficiaries? Well, one of the options is to set them up in joint names. And the advantages to that is when you pass, the asset will settle directly to the joint owner. And they're private. They're not subject to the probate process, so they're not public. The amounts or the assets aren't publicly known. They're known by you and the joint owner and anybody you decide to tell about these accounts. So they're harder to attack. The disadvantages are that the joint owner's problems become your problems. And this is the one disadvantage that I think precludes doing or implementing this strategy altogether. So if your joint owner runs into problems with creditors, divorces, has bad spending habits or excessive spending habits and accesses the account, that's going to be a problem for you. So generally, this is not a good strategy. Spouses often have joint assets. That's usually fine. Anybody that's an arm's length, dependent child, whatever, I highly recommend against it, as I think most advisors would. So it's there, but not really a viable alternative, especially when we get down to the options you'll see with segregated funds where you can maintain control, but still make them operate like joint assets when you pass. So RRSPs, RRIFs, and TFSAs, these are also your RRSPs. TFSA, just as a reminder, is a tax-free savings account. These settle directly to beneficiaries as well. The advantages are, again, the direct payment to beneficiaries. With the RRSPs and the RRIFs and the TFSA, they can elect to have the account come over to them without tax consequence. If you remember my prior slide, there was, for a non-spousal beneficiary, there was some $200,000 in tax liabilities. If the RSP is going to your spouse, the spouse can elect to bypass that in whole or in part and take the asset without any tax consequences. And again, these are private. They're not subject to the probate process, so they are accounts that are private, known only by you and the beneficiaries, so it makes them harder to attack. The disadvantages, I don't think anybody's going to be piling money into RRSPs or RRIFs if they can at their age for a tax planning strategy or a estate planning strategy, simply because the RRSPs and RRIFs, as you saw earlier, are 100% taxable if it's non-spousal. A TFSA, though, the tax-free savings account, there's no estate tax. It simply passes directly to the beneficiary because it is already a tax sheltered, or the returns are tax sheltered. There is no estate tax paid on it. So it actually is a very effective method of being able to transfer assets to your beneficiaries directly when you pass. But, and this is where I'm talking about the congruency of estate planning and lifestyle and wealth enhancement. A tax-free savings account allows you to save tax, or allows you to put money into an account and have the returns completely sheltered by tax. So there's a living benefit to it. Again, the two, estate planning and wealth enhancement, are not mutually exclusive. Now, trusts. Now, there's two types of trusts. I talked about when you die, there's a testamentary trust that is automatically formed, and that's something that just comes with death. So your assets that you have going through your estate or through your will are put into or are technically in a testamentary trust. You can, however, while you're alive, set up trusts, and they're called inter-vivos, or trusts while you're alive. Again, pardon my paraphrasing of the Latin interpretation or Latin translation. So you can set these trusts up, and there are certain advantages. The trust is a separate legal entity. So when you die, it continues on. If you have assets, if you've moved assets into that trust, it survives you. So it doesn't become part of your will or or even your estate, it is a separate legal entity and it continues on. When you set up a trust while you're alive, you have what you appoint what are called trustees. Very often this would be yourself, and when you pass, there would be another trustee appointed, perhaps a lawyer or a good friend. The assets are controlled and administered by trustees. So very often we see trusts in situations where there is assets being left to someone who maybe has a physical or mental disability and can't control the assets themselves, or perhaps somebody that has a lifestyle or spending habits that again lead them to being somewhat unpredictable as far as controlling their assets. So a trustee is appointed for them to handle that. And you would set out the terms and conditions of how that asset or how that trust is to be and the assets in it to be distributed to the beneficiaries after your death. Trusts can also provide income splitting. I've already mentioned the disability and lifestyle issues, but they can also offer income splitting opportunities where you can move assets, particularly revenue assets, into the trust and pay beneficiaries such as your children that may not or that are in not as high a marginal tax brackets as you. Again, they're harder to tax because they're separate legal entities, they're private, they're run totally aside from your assets that would be part of your estate. Disadvantages are they can be very expensive to establish and maintain. These are not, obviously you have people involved in them, trustees, that you have to have lawyers. You usually would have lawyers help you set these up. They have, because they're separate legal entities, they have to file tax returns. So you definitely have to look at the cost-benefit relationship of these trusts. They may also trigger taxation on funding. If you have, just like when you die, if you take a capital property, let's go back to our example where we had the stock portfolio worth $500,000 and your cost base or what it originally cost you was $100,000. Even if you're alive and you move that into a trust, you would technically trigger off a deemed disposition, and that $400,000 gain and $200,000 capital gain would have to be claimed on your tax return. So that's something you definitely have to consider on a cost-benefit relationship. And of course, it requires trustees and other ongoing expertise, which means money. It's going to cost, as I mentioned, they're expensive. And if they live past you, which most trusts will, for periods of time, you're going to have to pay people to run them. The living trusts or inter-vivos trusts are taxed at the highest marginal rate, which means that from when we're taxed as individuals, we're taxed on a scaled basis of what's called a marginal basis. We have a certain, if we earn a certain amount of income, it's the base income, if you like, the $20,000 is taxed at a certain amount, and then it increases incrementally as we make more. An inter-vivos trust is taxed at the highest bracket, approximately 43-44% from $1. So there's no graduated process as there is with individual taxation. So life insurance, now let's look at life insurance and estate planning, because a lot of the things that we're going to talk about or have talked about can actually be accomplished through life insurance. And for those of you out there that are maybe turning off a little bit going, well, we're past that stage, we've got our nest egg, we're comfortable, we've got our kids growing out, they've left. You're not, or may not be. So stay tuned to this, because there are some very, very solid strategies here that people in their 70s and 80s are using very effectively in estate planning. So the primary purposes of life insurance, just as a quick review, typically we do this as financial support for family. And as you're going to see, that doesn't just mean your direct family, it could mean your extended family as well. We talk about boomerang children coming back. We see this an awful lot where there's a tragedy in an extended family where one of the children, was a breadwinner, passed away, and all of a sudden the grandparents having a comfortable retirement are helping out to support providing financial support to the extended family. Also, other purposes for life insurance are business related. If you have a business and you're a key person in that business and you pass, life insurance provides funding to help that business either transition, wind down, whatever the case may be, but it replaces the loss of business income from you not being there, essentially. There might be other reasons too for you want to leave legacies to charities, foundations, etc. The other purpose, though, and what's becoming more and more popular, is life insurance also enhances legacies. For every dollar of insurance you purchase, every dollar of policy that you use to purchase a policy, you leave $1 plus to your beneficiaries. We're going to look at an example of that on a slide coming up, but that is becoming more and more a factor, and it's because the demographics as we get older, where we've settled ourselves, we have enough assets to live on through our lifetime. What we're looking at is a generation or two down the road, they're going to spend whatever we leave them. So if we can leave them more with this, using the same resources, provided it doesn't compromise our lifestyle, why wouldn't we? It's also, as I've mentioned, compensation for taxation of the assets upon your death. There's a deemed disposition. If that's, how are you going to pay those tax bills, or how are your beneficiaries going to pay those tax bills? If you've got a family cottage or a property that's the family wants to inherit, but it's going to incur tax consequences, are they going to have to borrow or sell against it to pay the tax situation? If you purchase a life policy, that can actually provide that funding to replace or to pay those taxes so that that asset can stay intact. We're going to see that actually insurance, even for individuals in their 70s and onwards, it can actually enhance your wealth and lifestyle during the lifetime. It's not just a death benefit. There are ways to structure insurance to enhance wealth and lifestyle, your wealth and lifestyle. One thing that a lot of people don't know too is that life insurance is a source of healthcare funding. Pretty much all the policies have in place a option that if you develop, or the insured, if it's you or a family member, develops a terminal illness, and that terminal illness is going to crystallize within the next couple of years, you can actually access up to 25% or $250,000, the lesser thereof, of the face value of the life insurance policy for any use that you may dictate while you're alive. So in other words, you're diagnosed with cancer, you are given 2 years to live, or expected life expectancy is 2 years. You can actually go to your insurer and access your policy to up to $250,000 to provide funding now for anything you want, whether it be medical treatments, whether it be a trip, whether it be family-orientated activities, whatever the case is, it's totally discretionary. So it has a very strong living benefit to it as well. So let's look at the estate enhancement I talked about. I'm going to use an example here. Now, you need 3 components when you have an insurance policy. You need somebody to own the policy, basically to pay the premiums. You need somebody to insure, and you need beneficiaries. And those are the 3 components you need. So in this example, we're going to look at estate enhancement, and we've got our gentleman here, we'll call him Lance, and he's age 70, and he's going to buy an insurance policy. And so he's going to be the owner, and he's going to insure himself. Now, I want to just stop here for a minute. The key point, or key word I just said, is buy an insurance policy. And that means he's going to literally purchase the insurance policy and own it, just as if he would purchase a house and own it, which means that once he transfers his savings into this policy, he no longer has to pay any premiums at all. He owns the policy for the rest of his life. So we're going to use a dollar as an example because in this particular case, I just want to show it on illustratively again, because everybody's situation out there is going to be different. Everybody watching this presentation has a different situation. Whoops. So he takes his dollar of savings and he moves that, and he buys a policy, and he buys an insurance policy by moving that dollar of savings into a tax-sheltered cash account that comes with the insurance policy. So again, the key point is here, he hasn't given up any wealth at all. He's simply moved a dollar from his savings into a insurance policy tax-sheltered cash account, and this is all CRA approved. So he's actually enhanced his position a little bit because he's taken money out of a taxable savings investment and put it into a tax-sheltered savings investment. And this blue arrow indicates that he can access that dollar that he transferred from his savings into the tax-sheltered account at any point in time. And so what happens is, this is all good. This is just a transference of savings. He's bought an insurance policy, transferred his savings, and if he wants to, he can access this dollar. When he dies, the insurance policy will pay $1.60 of death benefit. So again, I'll go through this again. Our friend Lance has put $1 in of his savings into this tax-sheltered insurance policy cash account to buy this policy. When he dies, $1.60 goes to his beneficiaries with no tax and no probate process. It's a direct settlement, and to his beneficiary, which be children, grandchildren, spouse, could use it to pay estate taxes, can go to his company, can go to a charity, whatever. This is estate enhancement. You take $1 and you make it $1.60. That's component, the first objective of the estate planning statement that you saw at the beginning of this presentation, getting assets in the optimal cost-effective way to beneficiaries. So he's optimized his dollar by making it $1.60. But the second part is, I'm going back here, Lance didn't have to give anything up to do this. He simply took his, if you recall, his dollar of savings down here, and he moved it up to this to buy this insurance policy by putting that dollar into a tax-sheltered cash account. So he pays no more premiums, and while he is alive, as I mentioned, Lance gets to use this money however he wishes. Again, when he dies, $1.60 goes to his beneficiaries, tax-free with no probate. So again, that's as simple as it is. It costs Lance nothing to turn his dollar into $1.60. And in fact, if you consider the tax sheltering aspect of the account, he's actually receiving an enhancement or benefit. Now let's look at something that's called transgenerational insurance. And again, we're going to look at this transgenerational insurance. I call it TGI for short. It's there to protect your extended family and your retirement lifestyle. We're going to illustrate that in the slides coming up. To get your mind thinking in this format, I want you to, we have a question that we ask, and I want you to take 30 seconds and just put down on a piece of paper the number of people you can think of in 30 seconds that lost their entire house to flood, fire, or earthquake. And once you're done that, you can pause this presentation. Then I want you to answer this question. How many individuals or families can you recall that had or were a child that predeceased their parents? So people you know that were children that predeceased their parents, or families you know that had children that predeceased their parents. Now in 30 seconds, when I did this question originally, I got, for question 1, I had 3. For question 2, I had 14. Generally, pretty much everybody I've asked has always had a higher number for question 2. And if we were giving you a minute to do this, the numbers, I think the spread would be even larger. What's the point of this question? Well, as pleasant as it may be, it helps us to focus on the fact, something a lot of people do not focus on, I'd say the majority, that the likelihood of a child predeceasing their parents is greater than losing your property to accident or nature. So if that's the case, if we insure our homes, why are we not insuring our extended families? Also, you should be asking yourself, would the survivors of your extended family require financial support in the case of a premature death? So very often, especially younger families, but even a lot of older ones, they've got so much going on with mortgages, raising kids, having 2 jobs, etc. Carrying insurance is unfortunately usually missed. And if they do carry it, they usually don't carry enough. So you may be comfortable in your lifestyle and you may be thinking, okay, great, we're set, we're good, everything's fine. You have a tragedy in your family and they come to you for financial support. How does that affect your retirement? So let's look at a situation. And we're going to look at a real situation on transgenerational insurance here. One policy we put together very recently. So again, you've got 3 components to an insurance policy. You've got our client here who is in this case, and we've got a client and he's got an extended family. And he's got a daughter that's 35 with a family. In this case, it was 2 children and a husband, both working. Our client had a portfolio of $600,000, and he was using that to augment his retirement income. His concern was that if his daughter passed away, that because they were a young family, they would have to come to him for financial support. They had very little insurance, and that would disrupt his comfortable retirement. So we put transgenerational insurance together, and I'm going to show you the 2 benefits this provides, because transgenerational insurance can also be used for estate enhancement as well as protecting your lifestyle income. And in this first slide, we're going to look at protecting his lifestyle and his income, his retirement lifestyle. So our client becomes the policy owner. And remember I mentioned there's 3 factors that you need for a insurance policy to be put in place: an owner, insured, and a beneficiary. So in this case, our client's the policy owner. If you remember in the estate enhancement, the client was the policy owner and the insured. But in transgenerational insurance, he insures his daughter. So he goes out and he insures, puts life insurance on his daughter's life. And how he does that is he has, as you recall, had a portfolio of $600,000, and he took $100,000 of that money and he put it into this. He bought a policy, which means he's paying no more premiums, but he bought a policy by transferring $100,000 into the insurance policy's tax-sheltered cash account. So our client still has access, as you can see, to $600,000. His asset base hasn't changed. The only thing he's done is he's realigned it. He's got a portfolio of $500,000 and a tax-sheltered cash account of $100,000, both of which he can access during his lifetime. So that really hasn't changed his situation at all. If his daughter predeceases him for some reason, then what happens is the policy cash account disappears, but the insurance policy itself pays, depending on when she dies, $500,000 to $700,000 of insurance proceeds to our client. So he insured his daughter, bought the policy with $100,000 of his, or put $100,000 into this policy cash account. His daughter died, and he receives $500,000 to $700,000 in insurance proceeds on her death. So what happens is that money goes into his portfolio now, which goes from the original 600,000 we looked at to 1.1 or 1.2 million, which he can now use to help his family, the survivors of his daughter's family with financial support without jeopardizing his original position. So again, he's created this $500,000 to $700,000 without giving up anything on his own side. So this is what we call zero cost insurance. And what he's done is he's hedged himself here. He's enhanced his portfolio by virtually double if his daughter were to die, so that he can help provide financial support without eroding his original position. Now, let's look at what happens, because I'm sure some of you are saying, okay, well, that's fine. That's a really neat plan. But what happens if the normal life cycles prevail and our client, who's 70, or in this case, I'm sorry, he was 67, predeceases his daughter? Well, again, let's look at the situation. His daughter is 35, insured. He's the owner of the policy. He takes his 100,000 of savings and he puts it into this cash account to buy this insurance policy. All right, that's exactly what we're looking at. I've left out the portfolio end just because the portfolio is not going to come into play here. So what happens if he can access this cash account at any time he wants through his life. So he's just simply taken his savings, transferred it up into the cash account. Now that policy is still going to generate a death benefit of $500,000 to $700,000, as we saw in the prior example, when his daughter dies. But what happens if our client predeceases his daughter? Well, he passes, and his daughter becomes the insured and the owner now. So what's happened is there's been a transition here, a seamless transition of her now moving into position of the insured and owner. So she now has access to the cash account, 100,000 plus value. So that's her inheritance, if you like. But what's being left in place is a death benefit for the grandchildren that didn't exist at all before this policy was put in place, that will eventually be paid out when his daughter dies. And the great thing is his daughter doesn't have any premiums to pay. The policy is fully paid for. There's no premiums or anything that have to be paid. The cash account supports the insurance policy. And of course, the beneficiary becomes the grandkids when she eventually passes. So this is why transgenerational is so strong. It doesn't cost anything, and in fact has some wealth enhancement values to it through the cash account, through the tax sheltering. But it also is an estate enhancement, because there's a death benefit that exists that will go to the grandkids that never existed before when the insurance policy wasn't in place. The daughter gets to inherit the cash value and use it however she sees fit, and the grandkids will eventually receive a death benefit when the daughter dies. The daughter will die at some point in time. We just don't know when. So what a great little vehicle this is, both from the standpoint of protecting our client, but even if our client didn't need the protection or didn't feel he needed it, he got to put part of his portfolio into a tax sheltered cash account and create a benefit 5 to 7 times that amount for his grandkids. I put a note here that you can also designate a independent owner if he wanted a third party or a professional, just like you would in a trust. So he could appoint a lawyer or a friend or something else as the owner if he didn't trust his daughter to properly manage the cash account. So what are transgenerational benefits? Well, just as a review, well, the owner can reduce or eliminate the financial risk that their extended family may represent to them in the case of a tragedy or a death, essentially. It can be used to enhance the legacy to beneficiaries. You just saw the $100,000 created a $500,000 to $700,000 benefit to the grandkids without affecting the daughter's inheritance. It provides tax-sheltered investment returns, and most importantly, it provides continued control and structure of the funds. In that policy that I was showing you, in both those policies, who maintains control of the money? The owner does. So our friend Lance doesn't ever have to give up control of his money while he's alive to implement this particular procedure, and he still has full access to it to augment his lifestyle however he sees fit. The structure is important too, in that the owners and beneficiaries can be changed at any time. The only component that can't be changed is the insured. So if for some reason the grandkids fell out of favor or a charity fell out of favor, whatever beneficiary fell out of favor, that can be changed very simply by a written letter. There's no lawyers or legal processes involved. It's simply a written instructions to the insurance company. What's the benefits to the insured children or the grandchildren, to the extended family? Well, Lance is providing them with estate protection for their kids, for insurance protection, if you like, and they don't have to pay any out-of-pocket insurance costs, and neither does he. So in other words, he's insuring the family to protect them as well as protect himself and his retirement assets. He can use those funds, as I've already mentioned numerous times, for future use. In the case of our client, the money that grows inside that cash account, and what I didn't show is that money actually grows. It will grow to more than $100,000 because there are dividends and other returns paid to that account. He's going to use that for education purposes for his grandkids, but he can use them for any purposes he wants. Again, there's potential healthcare funding too. If the daughter contracted a terminal illness, diagnosed to crystallize within 2 years, that policy could be accessed up to $250,000 for any discretionary spending purposes while she's still alive. Let's look at segregated fund investments now. And segregated funds are just like mutual funds that act like insurance. And as a quick review for those of you that may not know what a mutual fund is, a mutual fund is simply a pooled, regulated asset pool that a group of investors like you and me and everybody else put our money together, and we have a professional money manager manage a portfolio on our behalf. It provides access. Segregated funds have a living benefit. They provide access to potential superior growth and tax-preferred returns. They're RRSP, RRIF, TFSA eligible, so these are living benefits of this fund that you can realize while you're investing. Where they differ from mutual funds is that the investment and the growth, depending on your age and circumstances, are guaranteed at death to your beneficiaries. So mutual funds don't do that. Segregated funds do. They will guarantee investment and any growth to your beneficiaries. So you really are locking in your profits, if you like, and your original investment. You're protecting your investment for your beneficiaries. The other benefit is that, unlike mutual funds, these are paid directly to your beneficiaries. They do not go through estate or probate, so they are a regular investment account, but they go directly to the beneficiaries. And that is a huge benefit in that it gives you basically the benefits of having a joint account without having to have a joint account. You can designate the person you want to receive direct settlement of the account without having to make them a joint owner. There's no health qualifications. Insurance you have to qualify for. Segregated funds provide you with these death benefit guarantees and other insurance-like guarantees without any health qualifications up to age 90. And with these funds, there are some funds that offer you a guaranteed lifetime income option in addition to the growth potential, so that you will never outlive your asset. Let's look at an illustration. It's pretty straightforward stuff. Like an insurance policy, a segregated fund needs to have an owner, it needs somebody that's insured, and it needs a beneficiary, the same three parties. So again, we've got Lance here. He's the owner, he's insured, and he's the insured individual. He takes his savings, whatever amount that may be, and he puts those into a segregated fund. Now, there is no tax sheltering here, unlike a insurance policy. This is a pure investment, but there are, depending on how you invest, tax preferred returns that you can realize from segregated funds in the form of dividends and capital gains. And whatever he puts in is the fund value, and then that fund value grows depending on how the fund performs. Again, just like the cash value that we looked at in the policies, the capital and income, he has access to those at any time he wants in his lifetime. When he dies, then the segregated fund the value of the segregated fund will flow directly to his beneficiaries, the children, grandchildren, whatever that may be, and there's no probate attached. It's a direct settlement. It does not go through the will. It's not disclosed to other beneficiaries and all those other things. It goes directly to the stated beneficiaries. There could be tax implications, unlike an insurance policy, simply because this is an investment. So a very, very powerful tool, very easy to use, and as I say, it gives you all the benefits of a joint account without having to have a joint account and taking the risks of having someone else share your account. Annuities. Well, annuities are simply involve a lump sum payment in exchange for a guaranteed future cash flow. So you go to an insurance company and you say, here's a couple $100,000, and the insurance company says, thank you, here's what we're going to guarantee you for the rest of your life. Actually, and I should qualify that, you can also buy annuities for a term certain period of 5 or 10 years. Regardless, you will get something that pays you for whatever time you've specified, whether it's life or a specific term, a certain amount of income back. Now, there are some tax benefits to this as well, depending on how you choose to receive your payments. The negative side of annuities is in the true case of annuities, there's no access to the lump sum. So in other words, if you give your $200,000 to the insurance company, and they say, here's your annual income for life, thank you very much. A year later, you go, oops, I actually need $100,000 of that to, do a renovation on the house or to put one of the grandkids through college. They go, sorry, that money's committed. Just like a pension plan, you can't access it. Where annuities are being used in estate planning, again, like insurance, you can control the access to capital, where you have a situation without all the expense of having to set up a trust. So where you have a situation where there's a physical or mental impairment, or perhaps just a spending concerns that you have with a beneficiary, you can actually have some or all of all their legacy or the legacy you're going to leave them go into an annuity, and they will have very limited access, obviously, to the capital other than the annual stipend that they receive. So it's a very strong control vehicle. Annuities can also play a role depending on your age. As you get older, annuities pay more, and that can be sometimes advantageous depending on your age over other investments. So let's summarize. When we're talking about a will, don't die without one. But I think the emphasis of this whole presentation is a will is not an effective estate plan. If you are thinking that, okay, here we go, we've got these assets, let's get a will, our estate planning's done, it's not. A will can be a very ineffective way to settle your assets and your legacy. Where you can, as I've shown you various ways, organize your assets for direct settlement. It just makes sense. Have things go directly to beneficiaries. Understand tax implications and everything else, but definitely you want things to go as quickly and cost effectively to your beneficiaries. Without, part two, going effectively and efficiently to your beneficiaries without compromising your current wealth and lifestyle. And to do that, you have to make sure the benefits equal or exceed the cost of any direct settlement strategy, if there is one. Realize the extended risk that family, or the financial risk that extended family represents to you. Sit down and have discussions. Find out where your extended family's at. If they are going to be reliant on you in if a premature death happens, be prepared for it. Insure for it. Talking very briefly now about your advisors before we wrap this up. What I often do is say, look, make sure your advisors obviously are competent and networked. And by that, I mean, nobody is good at everything. I see ads all the time in newspapers and in online, etc., where lawyers say are doing estate planning, but they're also doing personal claims, they're doing criminal litigation, they're doing conveyancing, et cetera, et cetera, et cetera. Nobody can be good at everything. If you've look for people that specialize in estate planning. And that goes with all your advisors, your financial advisors as well. We work in conjunction very often. I'll step back here. We're not here to replace your existing advisors. We're here to work in conjunction with them. We specialize in designing these estate plans. And it doesn't mean that if you've got a financial advisor handling your investments or your other matters that you have to give them up. This works in conjunction with what you already have. And as you get older, estate planning usually becomes, if you're motivated that way, becomes more and more of a factor. So that we're not here to change your life. The things that we're looking at can be implemented very simply and within what you're already doing. But make sure you have specialists that know what they're doing. Financial advisors will do some of the stuff I've just shown you for you, but whether they do it correctly, and it has to be done correctly, otherwise there are ramifications down the road, will speak to their expertise. So we network. We work a lot with other advisors to put these plans together and make sure they work in conjunction with everything else you're doing. And that's the completion of the presentation. I hope you've enjoyed this. We're going to be doing some more of these, and we will be doing these in conjunction with some lawyers and accountants. So we'll be advising you accordingly. Also, we will be following up with you to see if we can help you in your particular situation. As I say, this presentation is fairly general in nature, but I hope you found some of this informative and useful. And I look forward to speaking with you in the near future. And with that, I will bid you a good day.